Hey, this is a little video of how to do a C100, especially if you are litigant in person or you're trying to just save money on your legal fees. If you are entitled aid or you are any form of benefits, I will also run through how to get the little code that you need to put with your form so you don't have to pay hundreds of pounds in fees.
First of all, get down to gov.uk website, type in help with paying forms and it will tell you whether or not you're eligible. Fill in all of your details as to what form you're applying for, the C100, your national insurance number, and make sure that you fill in all your details correctly. It will ask you certain amounts of questions, what benefits you're on, and it will work out your entitlement. If you are on any forms of benefits, then it will give you a code at the end. Make sure to give your full name and any details that will be on the court sheet. It's best not to complicate matters early on. It's quick and easy to use, and quite conveniently, it takes you on to the next steps. If you do the whole thing online, it will give you the code there and then, and you can enter this into your C100 application.
Hope it's useful. Good luck.
Now you're on to the C100 itself. If you type in on the same website, filing a C100 application, it will take you step by step through how to file an application. You can do most of these online now, and it is quite simple. A C100 is making a child arrangements if you separate or divorce order. Sometimes these things have to go to court when there isn't an amicable way of creating resolution amongst yourselves. If you haven't tried mediation, sometimes the court will request that you do this first. If that isn't applicable, then you file your C100 straight away. It talks about the court fees, but don't worry, you've just got your code to fill in, and it will tell you in detail all the things that you will need. This includes full names, addresses, and dates of birth of the respondent and the applicant. So that's your ex and yourself. So make sure you have those details to hand. Make sure you give the correct postcodes and addresses in order to the courts to contact the applicant and the respondent regarding all of your C100 matters. When it talks about mediation, be honest. If you are the victim of domestic abuse, this is where you would cite it. It would be a reason not to attend. But be aware that you may need to cite either police logs, non-molestation orders, or anything that you've put in place, including IDV workers and support workers. If you can't do this and mediation isn't possible, and you can give a valid reason, then you don't have to attend it. It is always advisable to try and mediate before court proceedings. The court will ask you a series of questions, and again, it is always in the best interest of the child long term to be as honest as possible. If you can't evidence anything, I highly advise that you don't try and make the C100 seem more exciting than it needs to be. Be honest and true to yourself. If there are any child protection concerns, there is no point in lying. If you think you can file a C100 and not tell them if social services are involved, you would be mistaken. In some cases where there is allegation of toxicity, then the court will actually enlist the opinion of the local authority and or CAFCAS on your child's behalf. If the application is urgent, for example, your partner has taken the child and you fear for the child's safety, then you would make an urgent application and you would declare that within the C100 online. So it's always important to be, as I've mentioned, perfectly honest. The C100 online will repeat some of the questions, and this is the same when you're filling it in. It's still important to answer all of the questions. They are tick box and they are repeated for a valid reason. As you can see, it asks you quite frequently about mediation. Mediation is something that you can both attend privately. There are many mediation centres out there, and a mediation certificate can be applied to the court and or proof that both parties attempted mediation, even if mediation failed. If there are any concerns regarding drug or alcohol misuse, then this can be noted as well. All aspects of child abuse and domestic abuse, drug or violence, psychological abuse and financial abuse should and would be taken into consideration by a judge when it comes to child welfare and the best interest of the child moving forward when it comes to custody arrangements. Physical abuse, financial abuse, domestic abuse, these are things that can really affect a child long term, and it's always important that the court sees that the best interest of the child is being met. It is always exceptionally important that we detail all allegations in the interim. So this means when you fill in your C100 form, always remind yourself of the reasons why you initially made the claim to court. It's always important to document behaviours and where you can, speak to support workers that you've spoken to see when your engagement with them began. It's also very important, if you believe that you've suffered psychological abuse, that you go to the relevant authorities and/or your doctor or GP and the relevant support networks. Again, financial abuse is something that you would be asked to prove, and we wouldn't recommend anybody using financial abuse or psychological abuse as a way of stopping contact for their child. The C100 application will ask you to go into a certain amount of detail regarding financial abuse, physical abuse, and this can be scenarios, times, places. These are things that will be called upon to determine whether or not there is a reason to look at this case under the guise of domestic or financial abuse. It's really important that you try and give as much detail as possible in the initial application so that the judgment and the severity of the hearing can be applied by the courts. When it comes to psychological abuse and to the arrangement of children, it's always imperative that all agencies think in the best interest of the children and their long-term welfare. Detailing financial, psychological or physical abuse is something that's really important to help the court understand where the children would be better placed. As with everything in the C100, it will ask for details. Some of it will seem laborious, but these details are exceptionally important. It's always important to try and promote contact early on. Even though your separation may be filling you with guilt, anger, hatred, hostility, and all the other emotions that go with it, it's important that you try your best to think also in the best interest of the child and be pro-contact. It's always important to read through the pros and cons of the court process. Don't forget, when entering your child's name into the court process, you are also taking them along for a very bumpy ride. It's also very important that the undertakings and the honesty that you present, as always, with everything, can be evidence and are in the best interest of the child. All children will be involved when it comes to the court process. Often, if hostilities carry on, then the court will appoint guardians, sometimes involve local authorities, CAFCAS, and these people will have an opinion in your court process. It's always very important to be honest in the application of the C100 and not to state things that you think will help your initial application without evidence. If you are going to be using professionals, it's always important that you put valid postcodes and addresses. If you're going to be serving papers on someone, then you have to give their relevant addresses and they have a right to respond. In the best interest of the child, it is important that you are as honest as possible and that both parties obtain all the information about the other party. Also, the courts will want you to work and engage with all agencies. However, if there are hostilities, then you are allowed to keep your personal information and new address free from the other parties. This is something that will be cited in the C100. There are occasions where GDPR breaches are made, and for this we do enforce and make sure that you say very clearly if there are any domestic abuse claims. This is your chance to ensure that you are kept safe. Make sure that all of the applicant's information and respondents' information are correct. Make sure that you have their current address and their postcode and all of their other details. This is really important. The applicant, in this case, you filling in the form, and the respondent will be your ex-partner. For whatever reason, whether the child is resident with you or resident with them, you will fill in a C100 form, and you will both or one or other of you will be expected to fill in and share all of your details. If I mentioned before that there is an issue, say there's an agreement, verbal agreement, that the child will be returned to one party and the other party has absconded with that child, then you may request an urgent hearing. You will put this online in your C100 application and you will have to detail this. If you have any fears regarding absconding or abduction, it's always important that not only you tell the courts but you notify authorities. If anyone is in any significant danger, of course, not only would you mention it in the C100 application, but also to any child protection or welfare authorities. If you believe that your partner has or attempted to apply for a similar order in England and Wales, it is imperative that you notify the courts of this. Also, your expressed wants, wills and wishes in the best interest of the child should be stated clearly in the C100. Although you're in a time of toxicity and bitterness, it really does pay long term to think about the benefits of pro-contact for both parents. Always detail any language requirement barriers you may have, special needs, assistance, and this may include advocacy, Mackenzie friends, or just someone to help you if you have problems understanding or dealing with technology if it's in line. Make sure your email confirmation is all correct. Nowadays, we don't stand in courts. There are options in some cases, but most courts are now run virtually via Teams or Zoom. Because of this, your email address is really important to the courts. It is nerve-wracking, but please double check any typos before you send. The last thing you want is your application being sent to someone else's email. It's now just a matter of clicking send and waiting for your court date. Best of luck. We'll all be thinking of you at Family Superheroes.